countries. So you do need a local partner to help you with all these things and navigate the fine print that you cannot read anywhere and the nuances. You need to make sure that when you want to protect your assets somewhere, that any contracts will cover the special aspects of that given country. Sometimes we do an assignment be that for trademarks, for patents, for all kinds of things, and we want to have one single assignment so that we don't have to bother the client with 20 documents to sign. So we often ask local agents first, what does need to be in a given contract, and then we adapt it. So we need the local expertise and knowledge. When a company wants to share or go into a partnership, they also have to think what happens in this country. Maybe you share bits and pieces in stages as you go along. You don't have to share everything up front. That's basically why I would say you need local boots on the ground, so to say, in order to consult with and help you navigate the various aspects.
Thank you, Sharon. We heard her well, that we have to understand the cultural realities of each country. Maybe she's from Israel and she wants to do business here in a registration here in UAE, so she has to adapt our realities and accordingly do the registration. Next question is to Krishna. We'll come back to you, Sharon. In Africa, from your experience, how is trademark protection evolving in emerging African markets? What key challenges and opportunities do these developments present for investors and brand owners?
Okay, thank you for the question. I'm Krishna from Mauritius. I'm with the firm INLEX MEA, and we cover Europe and African services for trademarks. So thank you for the question. The first part of the question is, how is IP emerging in Africa, in this area? So I will start with, when people talk about Africa, I'm not sure how many people here is from Africa. Great. Okay. So yeah, Africa is an emerging market for sure, and clients, when come to us, they usually have a fear, right? When come to Africa, what is going to be the next step? How are we going to navigate in Africa? And from us, what we're going to say is that Africa is now, most of the countries are TRIPS compliant, trade-related aspect of intellectual property through WTO, most of the countries. And secondly, with the accession to Madrid, we have more countries acceding Madrid. Next, the third would be with the regional systems that we have through OAPI and ARIPO, as most of you would know. OAPI with mostly the Francophone, and ARIPO with the mostly English-speaking. So Africa is increasingly being compliant to TRIPS, to trademark-related and national trademark laws. Yeah. Coming to the second part of the question, sir, so what are the challenges in Africa? One of the challenges in Africa is the fragmentation. When we talk about Africa, when a client comes to us for Africa, it's not one answer, because it is jurisdiction specific. We have 54 countries in Africa, and the strategy cannot be unified. Hence, our strategy is divided into 54. This is the reason why it's very important to know what are the challenges and what are the next steps to go ahead. The first issue is the fragmentation, but we'll get back to the solution into that. The other problem, apart from fragmentation, is first to file. That means that if a trademark is protected, the first one who filed the trademark has the prior right. So this is most important for clients to invest in Africa to protect their mark. What happened with the Western side, when they protect in Africa, they say that, okay, we protect in the US, we protect in the Western region, but when it comes to Africa, we keep it for later. Filing later is not the solution. The reason is that there are bad faith applicants. This is an issue, and then it's easier to file, and then you have your protection rather than the aftermath. Of course, there are solutions for that. You may proceed for cancellation action, etc. But this is more time-consuming and jurisdiction-based. It's going to be costly as well. So this is a problem in Africa, and there's as well to catch when people go to Africa. They might go to an agent who is less costly, or second, someone who is not very popular, or when we have issue, how to take enforcement action. So it's very important who you go in Africa. So this is a bit about concerns that we have in Africa, and I think the last part of the question is what are the advantages, right? Yeah. So for brand owners, why Africa? Because there are so many trademarks and that sectors like pharmaceutical, etc., which is less protected right now in Africa. I'm not saying that there's no protection at all, but it's not saturated like in the US and the West. So filing now has the importance of getting you registered rather than later having concern. And also with the digitalizations, e-commerce, it is globalization. So it is one world now, and not protecting now have concern for later. Yeah.
Thank you, Krishna, for the full knowledge about Africa. So we come back to you again.
Thanks.
We have same question really for Shimran. How important are local partners in protecting IP effectively? What cultural or business practices must often impact IP protection? How can companies balance knowledge sharing with IP protection when collaborating locally?
Okay,
Because you're from a different part of the world.
Yes, so I'm from India. Thank you, Mr. Rajesh, for putting up these questions. So to understand how local partners are important in IP protections, let's discuss a very simple example that we all can relate to. Everyone uses Google Maps, right? I think everyone have Google Map in their phone, right? So I have also the Google Map in my phone, and I have used this yesterday when I reached Dubai, and it really works well here. But earlier, during my vacation at Himalayas, there is a place called Jibi. When I was enjoying my vacation, the same Google Map experience was completely different. It was not working there, because their terrain and local conditions are completely different, because it sometimes led us towards the walking trails instead of proper roads. So this is how the local, because only the local partner can guide you at this kind of places to the right directions. So this is how the local partners are important. And next, what's the cultural difference we are talking about? Okay, so let's talk at grassroots level here. In India, there was never having the patent law in engineering instead of some pharmaceutical or biotech related courses where it is a part of curriculum. So when we don't know it, it's an alien, like it's an abstract. Considering the fact, when people coming into the professional environments, they're gonna learn about it first time. So maybe 90 or 80% people, they are going to learn this first time. And it's a story I had, so I'm correlating it. So when we don't know it, I don't know what does it means to business. So, because awareness gap in each country is different. So we need to understand that how much awareness is there. So what is the cultural difference? People might not have that much aware, like that are aware in US. So what might be the starting point in the US might be a halfway for some other countries. So this is the cultural difference. We need to give them clearly this value, that how the IP can create value for you. Like what really protection means for you. So this is a cultural difference we have in every countries. So like if I talk about India, if I go to the northern part side, the industry is less. If I go to the southern part, the industry, there might be a different situation. But if I talk about the western side, the industry is more. So see, culture and knowledge, everything is different. So we need to understand that the area, that how different they are from your center point. Then start from that. So this is the cultural difference I'm highlighting here. So maybe in country, maybe some other countries like India, the situations are now completely different what was 3 years ago. But if I might have to say 3 or 5 years ago, they might have to have courses for where their employees get to know about the IP and then tell them about the IP protections. So there's a huge difference. So the IP protection is being impacted by the cultural practices and business practices, and a local person can really add that value.
Thank you, Simran. We heard of that.
You have also asked regarding knowledge sharing, right?
Yeah.
So, okay. So for knowledge sharing, I guess knowledge sharing is one of the most important aspect in the success of any company. Like if I come from KPO, if I don't share with colleague, they will not grow. And I will not grow. If I talk about corporate or manufacturing, if I don't share with the colleagues, then they will not scale up. And scaling up of any business largely depends upon how much knowledge sharing you do. And when we scale up, there is a high chance that we fall back. So, company should first ask that what are the business opportunities. First you see the opportunities and then assess the impact of IP on that opportunities. So these are the differences I'm highlighting here for your questions. Thank you, Mr.
Thank you, Simran. So let's come back to you, George. How can companies balance innovations, localization, and IP protection without stalling growth in emerging markets?
Thank you, Mr. Rajesh. I'm going to quote Mr. Ghani in his opening speech, so I hope I'm not breaching any copyright laws here. He said that...
If it is not recorded.
He said at the beginning, people should think about IP that it creates value for the company, which is true. So we should consider it as IP create values, because you see many companies now change their branding, their logos and everything just for brand valuation. So it should not be stalling the growth. I'm going to talk about my experience at our company, how we do it. So we do our IP strategy in 3 parts. First is the core, which is the algorithm, everything behind it, which we keep it centralized. Then you have the adaptation, which is local implementation. When we do it we operate at Ooredoo in 12 countries, so we have the local implementation, local regulation, about data transfer, all of that. So that we sometimes can be shared. And the third part is the execution, the know-how. So in this strategy, it will help Ooredoo by many things. First of all, keep the innovation and share it locally, which reduce the friction or the politics between us and our local partner. Because sometimes in emerging markets, local partner does not understand why you're creating everything and not transferring to the JV. So we want to keep the rights for us. And second, so this strategy, by supporting the innovation and reducing and sharing it locally, provide monetization on a long-term run. That's why the IP is very important. Of course, we all know that leakage is unrealistic. So the end goal is about not to have any leakage, not any issues. It's about how to predict it, manage it, and to create value and reduce your IP exposure. I have a colleague who told me once that IP strategy is not a pure legal thing. It's legal and commercial. So I think, like I was saying at the beginning, in my due diligence, we don't take IP as serious, but now when you see it, especially if you don't want to get big fines in US, which I'm gonna let my colleagues speak about it more in the after it. So it's very important to have, from our side, this strategy of IP. Thank you.
Thank you very much, George. Next question I put to Sharon. Risk enforcement and future. How should companies measure IP risk before entering a new emerging market? What role do international treaties and trade agreements really play on the ground? Looking ahead, which emerging markets are making the most progress in IP protection and why?
I'll start with your middle question. The treaties, the local role they play is you can save time and money by filing PCT application, Madrid trademark application, as opposed to filing in many, many countries. So that's the actual role they play on the ground. Also, customs authorities might have to intervene if and when necessary, which is how these agreements do help for seizing counterfeit goods. Before going into a new market, I think every company should do their own due diligence and their homework and find out how their product is likely to be copied or infringed. What does the local law help or not help? Also, if you lose market shares because somebody is going to copy you anyway, do you still want protection there? Or is your profit going to be large enough in order to finance all the litigation you might have or the loss of the market share? And also maybe when I have had a case a few years ago within a local startup company. They received some funding and they were very happy about all the funding they received, and they filed in, I think, almost 20 countries, spent all the money they had on these 20 patent filings, and then a few years later all these patents came to examination and all their money had run out by then, and funding did not come forward anymore because we had other problems. So many patents which were in examination had to be dropped and left these markets unprotected, and some other countries where actually they did have granted patents, they died sort of, or became abandoned because the company lost the funding and couldn't even pay the annuities anymore. So again, maybe don't file in 20 countries, maybe think which markets are the most crucial ones and focus time and energy on those. Sorry, I just make my notes on the phone, which is why. Now, Israel may not be an emerging market per se, but we do have some nice things which other countries may not have. Everybody, or many countries have PPH or have acceleration based on age or based on all kinds of other aspects. In Israel, we have another option to accelerate patent application by being a first application. If you say this is my first application of a given invention family, then you can accelerate it for a fee, of course. And they have recently expanded this option also to include, if your Israeli application is a regular convention filing, if it claims priority to a US provisional, you can still accelerate it based on first invention case. Many countries have recently adopted PPH agreements with the scenery changes so frequently, I cannot keep track of them, which is why you have to make sure that you always consult local colleagues. I had a case many years ago where we actually managed to get a patent in Brazil as a first case in a family. Brazil back then was still took still a very long time, and it was a case involving green tech. And we got the Brazilian case allowed, and actually managed to use PPH later on in the US for this particular case, which was the first for me. I never had this, that the Brazilian case was granted first in a family. So this is another reason why you absolutely need good local contacts, because if I had not had a good contact in Brazil, then he would not have been able to help me through this green tech accelerated examination and tell me, but this is a very specific case which does not normally fall into it. So another example of why we need good local representations.
Thank you. Thank you. Next question to you, Krishna, about Europe. How can international companies leverage strong trademark protection in mature jurisdictions such as EU, IPO, UK, France, Benelux, Switzerland and Monaco as a part of a broader IP strategy when entering or expanding into emerging markets?
Yeah, thank you for the question. As we all know, offices like the EU, IPO, UK, France office have rigorous trademark examination, and once we receive a registered rights, a registered trademarks in both European countries and even the USA. So this form part as a very important trademark protection. Now, the question is like how a brand owner can use their registered trademarks in the EU or UK to support them when going into emerging markets. As we all know, trademark rights are territorial. There's no doubt about it. Trademark rights are territorial. However, trademark rights in strong, robust offices like the EU, IPO, France, etc., they do have impression on other market countries. So if a brand owner have registered rights, for instance, in the EU and wants to go into emerging markets like the Middle East or Africa, what are the advantages? The first one I would say the priority rights, of course, this we all know, priority with Madrid, etc. So we can also use this as your base market for filing in Africa. This is the other thing. But here, what I would want to discuss more is how having a registered right in strong markets like, I would say, mature markets like the EU is, especially when tackling bad faith applicants in Africa or Middle East. Brand owners can use their registered marks to show that they have a reputation, that they have, of course, like they have been using, they can prove the use of their mark in the European markets for long, and then we have seen such cases in Africa. Despite they have, the first file, for those who first file has the right, but there's no doubt about it. But in examinations, when you be able to prove that you have a strong portfolio of marks in mature markets, this supports in examination procedures. So this is helpful. We also seen that like brand owners, they file directly in European countries, in USA, but when they go to Middle East or Africa, sometimes they go through their distributors or licenses. And what happened over agent? And the agent sometimes, or their distributors, file it directly into their names rather than on the brand owner's name. So this causes issue later on, needs to conduct a license, etc. So having strong trademark protection in the USA, European countries would definitely help when addressing such matters. Yeah.
Thank you, Krishna.
One second. There is something I forgot to mention before. I had it in my notes. There is one thing which I think I've only read about it in one other place. We also have in Israel a system for accelerating examination if at least 50% of the inventors are women. So that's another nice thing as a side note.
Thank you once again. Next question is to Simran. Simran, again, on how should companies measure IP risk before entering a new emerging market? What role do international treaties and trade agreements really play on the ground, looking ahead, which emerging markets are making the most progress in IP protection and why?
Okay, thank you, Mr. Rajesh. For IP risk, I guess the IP risk comes under only the business risk. If you are not generating any revenue from your IP, then what risk are we talking about? As I've mentioned earlier, we should first look at the opportunities, and then you assess the impact of IP on that business opportunity. The impact is of two types, the risk of litigation and the opportunity loss. Let's suppose I'm Apple. I'm selling my product in the market, and those who wants to buy the iPhone, they will definitely buy the iPhone because it's a status symbol. I have also bought the iPhone 17 Pro Max because it's a status symbol in India, because branding works a lot in India. So what matters here the most is to protect the trademark first, so that I can protect my mission critical patents instead of this, because no one have to deal with the technology. So this is IP risk should be accessed like the market risk before entry, not after the loss. And for your second question is international treaties. So there are a lot of international treaties which are helping a lot, like PCT. They are a lot dependent upon the scenarios. Like in PCT, they are providing us 31 months to bring a patent in different countries. So this is I'm talking from the business perspective. So on this, patent attorney can really tell clearly on this topic, because I can have my patent attorney who can speak on this international treaties really well. And for your follow-up questions, which emerging market are progressing really well? So as I came from India, so obviously I'm going to say that India is progressing really well. But just to substantiate this, I think it's possible to say this because we got more than 1 lakh filing in a year of patent and more than 5 lakh trademark filings in last year, and I guess 30 to 40,000 design patent filing. So I guess it's more than 100% growth. And secondly, in India, the government has taken the initiatives to support the startups and MSMEs. There are several schemes they are providing so that most of the startups can take avail or benefits, can take advantage from the governments, because governments are ready to pay your professional fees now. So you can protect your IP globally now. So this is how our government is protecting. So you all can come to India. We welcome you, because if you do, you want to do the business, you want to look for the opportunity in business in India. So we welcome you, because our population would become the strength. They would become your market strength. So that's all.
Whosoever goes to India for registration should contact only Simran.
Yes, please. I'm ready to help at any time.
Okay. How many of you attended last IIPLA session? 2020. There's one lawyer who mentioned the number of registrations in a year worldwide. Does anybody remember? 1.4 million trademark registrations. So it's a big market, and India is emerging as one of the topmost.
Yes.
At present.
So I'm waiting for you guys to welcome in India.
So while putting the last question, will be like a snap question, 1 minute answer. It's on the spot. Can you pass on the mic to George?
Yes, please.
What is one IP strategy? This question is for all of you. What is one IP strategy you wish clients understood better before entering emerging markets? If you had to redesign IP protection in emerging markets from scratch, what would you change?
Enforcement, because most emerging markets have laws, but there's no enforcement.
Okay. Anything to elaborate? We have 1 minute.
Okay, so for example, I'm coming from Lebanon. In Lebanon, for example, if you want to have HBO or Paramount or any of the streaming, you don't need to go and subscribe directly for it. I'm not promoting this. I'm just giving.
Sounds like it.
I'm just giving a live example. In Lebanon, you have all the modern IP laws, the trademark, the copyright, the patent. You go register it through agent, register in the ministry. You have the protection. You go to court if someone. But in a neighborhood, one person go buys a license from Paramount or Netflix, and then he, for some reason, how we does it, he gives it to your house, all the access channels. So that's why I said it's about the laws and about how you design it from beginning, the algorithm, the core, how to protect it. I took more than 1 minute.
Thank you.
That's
You
fine.
want me to repeat the question?
I'm your neighbor, so we will just VPN to you, and we will take all the.
Oh, I forgot about VPN also. Also now
You want me to
VPN.
repeat the question?
Yes, please.
What is one IP strategy you wish clients understood better before entering emerging markets? If you had to redesign IP protection in emerging markets from scratch, what would you change?
One thing I would like clients to understand better is to think before they speak, to put it bluntly.
I should have done that.
Because we had so many cases where on a Thursday evening, which our weekend is Friday, Saturday, on a Thursday evening at 6 o'clock a client calls and says, "Oh, I have a conference tomorrow, can you file this?" Or, oh, I spoke this morning, can you still file it? So that's one thing I would like clients to understand better, to think and before they do something, or consult with their patent attorney, or with a patent attorney at least. What I would like to change is mainly for applicants to make it a bit easier, less costly, and not so long. That it takes many years sometimes for, in the US we wait 2-3 years for first office action until we track one, and that not everybody can afford that. So that's one thing I would like to change.
Thank you. Krishna, you have the question?
I have the question. For me, it will be the client needs to understand the context specific when entering any market, because any market we want to enter, we have different languages, different laws. In some country, like if I get Africa, we have different laws, common laws, French laws, and as well mixed systems. So this is very difficult to navigate in such. So we need to understand this, and there is no one right answer. With proper strategy, this will be able to do. Just to follow up on that, I know with WIPO, people think that it's easier to enter any market. The answer is, hopefully, I would agree, it's easy to enter the market, but the aftermath, how to manage these opposition or in any context. Again, this will be context specific because of underlying issues that we need to take care of. Yeah.
Sharon, you have the question?
Yes, Mr. Rajesh. So for me, the future of IP in the new emerging markets is not about copying the foreign models. It's about aligning the law, cultural, and commercial incentives. And we need to keep balance in knowledge sharing. Like, for example, if this is a paper, I can speak like if I hold this paper, all right, and if I hold this in this hand, it is solid and stiff, where the same paper in this hand gets folded. So where is the balance? Right? Because every company has different environments, so the knowledge sharing for every company is different. So it depends upon a lot of on the multi-factors determinations. So we have to do the multi-factor determinations before striking onto the balance. So share only the necessary things, not everything. That's it.
So guys, everybody has heard them. Same question to one part of the world and to the next part of the world. It all differs on the cultural realities. Yeah. So with this, we end our session. I hope you enjoyed. Let's have a round of applause for the speakers. And even if you have not enjoyed, please applause.
And for our moderator.
May I ask if the audience has any questions?
Any questions?
I have a question. Thanks, George, for a comment. I think the U.S. lost its moral rights a little bit to talk about enforcement, but just a question about U.S. actually based. When you clients or your strategy with respect to U.S., especially on the trademark side, the use requirement in the U.S. is very strict and has been enforced specifically, I think, maybe unevenly against the foreign filers. Do you guys consider that in your strategy, or how do you react to that? I don't need I just wonder, because this is what we as a patent and trademark attorneys in the U.S., we deal with USPTO, I personally, my firm deals with thousands of filers in the U.S. and coming from different emerging and non-emerging markets, and it's always, the use has been tremendously problematic for a lot, and so just wondering where you guys are.
I have one answer.
It's on.
I have one client in one of my various freelance in-house positions. I work for a big company, and way back when their marketing department decided on a list of countries where the trademarks are to be filed, which is what was done, and then years later down the road, you come to the allowance and need to file proof of use. Oops, we can't proof of use. Oh no, we're not actually using it in this form. Is what the marketing department then said. So nowadays, that was back in the old days. Nowadays we have in-house IP people who work for the company, so now they think wait, we cannot file this because if we ever need to prove that we actually use it, we can't. So yes, things are a bit shifting, and we know that it's not just the US, there are other countries as well. We had to prove use in the Philippines, which again wasn't possible back then. So I think clients need to be aware of the pitfalls of having to prove use and not just file before actually checking the local markets. But yes, it's not a discrimination that we have experienced, but more like a hardship that has to be taken into consideration.
Not discrimination, it's just US requires
Like
change.
the US filers have the same.
I mean, from our side, we are registered our trademarks and logos and everywhere in more than 100 countries. The most difficult one to get it registered in US.
Next question.
Yes.
Hi everyone. You want to
Yeah, just to add into this, for the I'm talking in regarding the cultural difference. In India, there is relationship building culture. So many disputes arises because technical details are shared before the NDAs are signed. So we should file locally and locally patent and trademarks before collaborations. So this is the point I'm highlighting here. And that's all.
Hi everyone, thank you for a great session here. My question for George, with a company like Ooredoo, where you have different locations that you need to also implement and protect your IP, and also having into the context what you were saying about poor enforcement in some countries. I was interested in knowing when you guys are persuaded to have your IP as trade secrets over filing a patent protection. What practically can make you take this decision?
At Ooredoo, mainly we keep everything, the core IP, we keep it centralized. We don't develop it in local countries. Because of leakage, people will try, because you cannot, I don't want to say it, but local culture, government employees, they are influenced, so it's not easy. So everything will keep it centralized. And everything is registered under the group level. We don't register under the OPCO level. Also because we might have issues with our partner. So we rely first of all on our local partner to do the registration for the local developed IP. And we use also firms who are experts like this. I don't want to mention names because I don't want to publicize, but in the area you have many law firms, not law firms, IP agents, which can help you with this one. So everything we keep it in Qatar, and we develop certain area at the OPCO level. So the trade secret, everything is registered in Qatar. We don't develop it in local areas, especially where in our market we are all emerging. Not leakage is amazing, but like we operate in Singapore, we do it properly because there is enforcement.
Can I say one line? Being a moderator also. If you keep a secret of any of your practice, like I have done enforcement right when enforcement started in UAE. We have worked very discreetly, internationally, and we have always been successful. So you have to be very secretive on how you operate to get your success involving different agencies, different level of enforcement. That is my suggestion. Any other question?
Any other questions?
So everybody is happy?
Okay, so I'll now request our moderator, Mr. Jagasia, to honor the panelists with the mementos. Thank you.
Thank you. Thank you.
This is for Sharon.
I think everybody has eaten outside. Can you applause? Can you clap? Ma'am, look this camera.
Krishna.
Clapping will be a trade secret, don't worry.
Please wait, we will have group photo. Yes. Please be on the stage.
Up or down?
And this is for our moderator. Thank you so much for your coordination.
Yeah, please come like this. Krishna, so you will be there.
Look here, this, look here, sir. This camera.